Welcome to the McGill Alumni Association of Northern California's virtual event. What's fantastic these days is that you don't have to be Northern California. You can be anywhere in the world. So thank you for joining us in this event, specifically for alumni living in the US or traveling between Canada and US during COVID. If you're not already, please follow us on Facebook or Instagram to get the latest updates on the events. We are always looking for new ways to get the community together, and we value your feedback. In fact, this event was ranked #1 by a landslide. This is a topic that is very dear and near to our hearts, so thank you, Connie, for being here. So without further ado, I'd like to welcome Miss Connie Kaplan, who has so generously offered her time to speak to the McGill community today. So Ms. Kaplan dedicates her private practice exclusively to immigration law, so she knows her stuff. As an immigrant herself, she has had to navigate many of the same issues that we all have. And she has a bachelor's degree in business from the University of New York and a law degree from Nova Southeastern University. She is also a member of the American Immigration Lawyers Association, where she has served on South Florida's Customs and Border Protection Committees. Disclaimer for everyone, this information is not intended for legal or advice. We recommend that you contact Connie after this presentation. Her information will be shared so that you can get consult on your specific situation. So Connie, the floor is yours.
Well, it's a pleasure to be invited here, and it's a pleasure to be here. And before we begin, I just wanted to address a few things, which as lawyers, you all know we need to have, which are disclaimers. So again, thank you for inviting me. We are going to talk a lot about COVID-19, Canada, travel and immigration in general, but there are a few things to remember. This is not a privileged communication. There is no confidentiality that attaches to any conversations we are having here. So if it's anything really personal that you'd like to discuss, this is not the forum, but general questions are very welcome. So feel free to put them and ask those questions during this time, and we'll be very happy to address them at the end. There is no attorney-client privilege and no professional relationship between me and any member of the audience. Again, there is no legal or financial advice given for your particular situation. Now, this is a very broad topic to cover, and we have tried to incorporate as much as we could in a short period of time. So I will be speaking very fast, and I'm hoping you guys can follow. And I will also be saving some time to address some of the questions that have been presented when we sent out the poll, because we want to make sure that your particular questions are addressed. Also, some of those questions and some of these issues, because they are cross-border, affect people differently if they are looking to move into Canada or travel back to Canada, and Canada immigration law will apply. I cannot speak as to Canada immigration law at all because I'm only licensed to practice in the United States. One of your fellow graduates from your university, Jade Culver, was supposed to be here with us today, but she just had a baby girl, so we wish her congratulations. And she couldn't be here to address the Canada portion of anything that pertains to Canadian immigration. So let's get on with this and get going. So once we understand those, what are the most recent difficulties? We're going to address some of the visas that are very common. Okay, first are the H-1B visas, O-1, T-1s, L, and so on. Those of you who are going to ignore the visas that you don't recognize because it probably doesn't apply to you, but we wanted to address a wider audience. So the COVID-19 crisis has led to many changes to employee-related immigration processes and procedures. Some of the most heart-wrenching terminations that employers have had to make during the last few months have been those of employees on H-1B visas. Let me start everything by saying that The current administration's policies are buy American, hire American, which in its face, it is nothing wrong with it, but it affects H-1B holders disproportionately. This will not be a political discussion, and this will not be an discussion of the current administration's policies. But H-1B visas keep coming back, and there were recent changes on how those are being handled as of last night, and I have not had the chance to review the newest regulation, okay? Employers are often surprised to learn that, for example, not only some of the employees are not eligible for unemployment benefits, but they and their families may be required to actually leave the United States within 60 days of terminating their employment, unless they can find another employer willing to sponsor them. Within that short period of time, it is rather difficult, especially in this economic climate. Employees on those visas do not have those that don't have prevailing wage requirements, such as O1 visas for exceptional scholars and others, TN and L1s. They are slightly better off because they may be temporarily furloughed without pay, provided that their status doesn't expire during that period of time. However, if the furlough lasts beyond the 60-day grace period permitted by USCIS, then these employees will also need to leave the country. Employers can also reduce the hours and salaries of these employees without impacting their status. Now, that's only to a certain extent, and it really depends. If the original petition stated that the employee was going to work full-time, the employee's hours should not be reduced below 35 hours. When do you need an attorney? This is just basic, so going really fast. If you hold a U.S. temporary visa, such as an H1 or an H1B or an L1, and you lost your job, you need to see if you can avoid overstaying the visa and accumulating unlawful presence. The consequences of an overstay can ruin your chances of obtaining any other type of visa later on in time and ultimately immigrating to the United States on a permanent basis. It can also affect your ability to visit or even work again on an H-1B or an L1, or even just visit the United States on a B1, B2 visa, regular tourist visa for business or pleasure. If you have been laid off or fired from the job, or if the company announced imminent layoffs, you need an immigration attorney to understand your rights upon the layoff, and also your obligations that you face as a temporary worker in the United States. In order to avoid the conflict of interest, you need to remember that when you have an employer and employee relationship, generally, the lawyer doesn't represent, the lawyer that you're going to consult with doesn't represent the interest of your current or your future employer. Although an attorney or a law firm that represents both the sponsor, the employer, and the employee is supposed to represent the interest of both parties in a dual representation agreement, that duty ends when the employer decides to terminate the foreign worker. At that point, the attorney who represents the company cannot and should not engage into any advice towards the employees or to help the employees, because that would breach the duty that the attorney has towards its employer, which is the sponsoring employer. If you fear that you would lose your job or be terminated as a result of COVID-19, you are strongly advised to consult with an immigration attorney, one that works with you necessarily for the employer or the future employer. What happens when you're terminated? I'm not going to go over this. I'm barely going to read the slide because it's a lot of information. You can stay up to 60 days upon termination. It is either that or 60 consecutive days or the end of your authorized validity period, whichever is shorter. So if you have only 30 days left, if you're in your H-1B, you don't get 60 days just because you only have 30 days left. If you could potentially change to some other status, you could possibly do that. It is very difficult to change from a current employment status back to a student visa unless you are advancing in degree. So say you have a master's degree, then you got hired by an employer on an H-1B, and now you are faced with furlough, layoff, and so on, you could consider going for a PhD program and get an F1. If you're on a different type of visa, it might be more difficult. An employer would be able to rehire a foreign national employee before the grace period expires. We have seen a couple of employers do this. They hire, then they furlough you again, then it's just a nightmare. So the issue with the H-1B visa holders is that there is a labor condition application. I'm going to call it an LCA. Most H-1B visa, if you're on it, you know what that is. It's required in getting the H-1B status. So when they file that LCA, the employer has to attest exactly the terms of the employment, including the prevailing wage, which is the rate of pay that they need to support. And they need to show the salary that they're going to pay the employee and the locality in which the individual will work. This comes into play in particular now with COVID-19, as especially in Silicon Valley and the West Side. By the way, I'm in Florida. I am not on the West Coast. So it affects significantly people on the West Coast and in the Northeast area. So layoffs or furloughs can change the terms and conditions of employment that were provided to the Department of Labor, specifically the work location. So employers can change the terms and conditions. So when your location changes, you no longer go to a physical office, you no longer go to a specific work location, and you are allowed to remotely work. If that is not within the same area, then a new labor conditions application needs to be filed. Some employers choose not to go through that. If an H-1B visa employee is being switched from full-time to part-time, changing would require the employer to file an amended petition with USCIS before the change can even occur. This is not after, it has to happen before. If you are laid off, the employer must, they don't have a choice. The employer must withdraw the underlying labor condition application. They need to notify USCIS of the termination of employment, and they must pay reasonable cost for you to return back to your country. For yourself, they don't have to pay it for the family. Okay, it doesn't apply if you voluntarily choose to quit the job or if the employment is terminated because the contract expired. So if you are furloughed, let's talk about paid time off and sick leave. You must continue to receive the required salary indicated under the underlying labor condition application. Okay, that's filed with the Department of Labor, and the H-1B visa petition forms filed with USCIS. Any material change to the terms and conditions of the employment, such as discussion in salary, to what is stated in the underlying forms that were filed, such as a reduction in hours from full-time to less than full-time, or a change of employment location outside of the intended region, requires that the employer must first file an amended LCA with the Department of Labor. In certain situations, though, this may be possible, but such situations must be reviewed with the Immigration Labor Council to ensure that they adhere to the H-1B requirements, and the paid leave. When COVID-19 started, the federal government passed the Families First Coronavirus Response Act, the FFCRA, that has specific provisions for paid leave for employees, and people on H-1B are also covered by that. The Department of Labor has indicated that furloughed employees are not eligible for paid leave under that. The furloughed employees may be required by the employer to exhaust the accrued paid time off as long as they are not required to do so before taking any leave, okay, for which they may be eligible under the FFCRA. We see this coming up quite a bit when the employer is trying to terminate the employee, but they have a contract in place. Not all H-1B employees have employment contracts. So, can you work remotely or not? Many employers are having their employees work from home if possible to encourage social distancing and to comply with various state and citywide shelter-in-place orders. For employees in H-1B status, it's important to ensure that employers maintain compliance with the federal regulations. Remember, the H-1B program is jointly regulated by USCIS, which is Homeland Security, and Department of Labor. Department of Labor require, on one hand, that for an H-1B petition, employers must submit the LCA, including the location. And the key requirement states that there is notice that has to be posted, okay? The actual work site where the H-1B company was going to be employed, or electronic notice. The electronic notice may be on the company's website, intranet, or its newsletter. We're not going to go into that. I don't think we have employers in audience that I think we have mostly employees. So if the H-1B employer work site, again, I address the work site because this is a huge issue, will work from home now. It's not addressed in the approved LCA for up to 30 days each year. You can still be up to 30 days working from home. In certain situations, it may be extended for an additional 30 days, up to 60 days maximum in a 1-year period, as long as the employer shows that the employee is still still maintains a residency in the initial labor condition application. If the temporary assignment is longer, it's been longer than 60 days, right, that we have had this pandemic, the employer must file a new labor condition application to cover the employee's residence and comply with the requirements, the notice requirements, and file an amended petition. I addressed the work site. I'm not going to address the work site. Let's skip over that. If you are requiring leave for quarantine, an employee that is on H-1B may be eligible for paid sick leave, like we addressed under the FFCRA. However, unemployment benefits, generally foreign national employees on a visa cannot claim unemployment because they are not considered available for work. To break it down into pieces, Department of Labor requires that you certify, when you apply for unemployment, that you are ready, willing, and able to work. You may be able, you may be ready, but I'm sorry, you may be willing, you may be ready, but you are not able. And you are not able because specifically for H-1B employees, you are tied to a specific employer. If you have been terminated by that employer, the specific work permit, so to speak, under which you are allowed to work limits you to that specific employer, which means you are not able to work for other employers. All right. So your spouse, if she is on H-4, may be eligible to obtain unemployment as long as you, the H-1B employee, remains in status. We kind of done with H-1Bs. We'll get a little bit back later on, but E-1, E-2s, L-1, O-2s, and T-N visa holders. They are not location specific. You can work from anywhere as long as you work generally for the same employer. They will forgive, they are very relaxed as to those kind of visas. They will forgive remote working arrangements. And those who are on F1 OPT status, ICE is responsible, and they are very difficult in coming up with guidance as to how they are going to interpret that, okay? H-1B, again, they have not issued guidance how a furlough would impact their statuses. You still have to have a minimum of 35 hours if it's an employee whose hours are being cut from over 40 to lower, okay? So if a furlough requires a significant cut in the number of hours, then a new labor certification most likely will be required. Reduced hours we address. Salary reduction. Salary reduction does not constitute a material change that triggers a need to file an amendment. You may have been called in by your employer and being told, we need to reduce your salary by 20%. You still have the same job. You still have to have the same location. It's not a material change, so no change needs to be made in the labor certification application if there is one, or the USCIS petition. L1 and TN employees are not eligible for unemployment benefits because their employment is tied to the specific employer. F1 are not eligible for unemployment because they are not able to work at all unless they are on OPT, in which case applies to that specific employer only up to 90 days. If you are on an H4, we discussed, and L2 status, if you hold an employment authorization document that allows you to work for any employer without the need to go through a labor certification or recruitment process, then you may be able to obtain benefits. Now, I have seen that the travel restrictions, it's one of the hottest topics, so let's go over that. You may, in response to this, okay, both countries, Canada and the United States, are restricting travel, okay? I don't know why, hold on a second. One moment. There you go. This is where we want to be. Travel in Canada. Travel to Canada for discretionary reasons, such as non-essential travel, for example, for tourists, recreation, or entertainment, is currently prohibited. If you are a Canadian citizen or a permanent resident, or you are the immediate relative of one, different restrictions apply. Now, to prove, you have to prove to Canada, to the CBSA, that you have to prove that you're traveling for non-discretionary essential travel purpose, or that you are an immediate family member. You have to show that you're not presenting symptoms of COVID-19, and you have a plan to quarantine for 4 days unless you fall into one of the exemptions, and they are very limited. If you are the immediate family member, then you have to meet the entry requirements, and then you also have to show the COVID-19 requirements, means you don't have to, you don't have any symptoms, you haven't been diagnosed, and so on, and that you have been quarantined. It seems like the quarantine is the biggest issue. Now, we are going to talk. If you have additional questions, please save them and feel free to send them in. We didn't address a lot of the travel issues. We were hoping our Canadian partner was going to answer those. But before we go to the Q&A portion, I want to address some of the questions that have come up when you responded to the poll that we presented. And I'll go over those in order, and then I will address whatever questions you have. Remember, US law, I can't address Canadian law. If I am on a TN, is there any risk with visa re-entry if I go to Canada while there are border restrictions? Let's address what border restriction means first. Border restriction is not necessarily what you would consider a border, okay, the border between the United States and Canada, the land border. An airport, it's also considered a border, okay? The current restrictions in place, even though they don't make any sense to me, restrict cross-border crossings by land. They do not necessarily restrict travel by air. That being said, we have had clients, both US citizen and Canadian citizens, either or, travel both ways without any issue whatsoever on the land border, even though it's fully restricted according to the regulation. And we have also had we also had clients who tried to travel by plane and they have been denied boarding. Generally, it comes down to you being able to prove either that you have an immediate family member or that you are an essential worker. Anything else, generally we have noticed the Customs and Border Protection officer consider you to be a non-essential worker. They don't consider immediate family or immediate relatives, and that's where that comes in. This question comes from an individual who's both US and Canadian citizen, born in Canada, and the question says, I retired this year from a career in the US. My retirement income is a company pension and US Social Security. My investments are US based and also include ownership of a house. I don't have any specific questions and other than any advice or checklist of issues I need or should consider. Okay, what you're not telling us, okay, is I understand you retire, but it depends the age at which you retire because you may be entitled to benefits under the Social Security Act in the United States, you should consider talking to a Social Security attorney here or a financial advisor who can tell you if you are eligible under the US force. If you can keep getting the Social Security if you move permanently to Canada, if you would have to repatriate back to Canada if you were born there, it doesn't say where you were born. And what you also need to consider is dual taxation issues. You are a citizen of both. Under the US laws, and I cannot give tax advice, under US law, you must declare, you must file your taxes every single year, as long if you are a permanent resident of the United States or you are a US citizen, and that you have to declare on your worldwide income. So assuming you are moving back to your country, or you're moving to a third country, any income, rental income, say for example, you said you still have a house in the US, if you would receive rental income, you would have to declare that in your Canadian tax return. Tax treatment of pension, retirement, worldwide income in terms of dividends, capital gains, and all that, it's subject to the treaty between the countries, and you would have to talk to a tax attorney or a tax professional to advise you on that. We see quite a few people who want to know, well, what are my tax ramifications if I want to live in one country versus the other? And the simple answer is it depends on the treaty. And there is no such, everybody calls it a double taxation. It's not exactly double taxation because we give full faith and credit to the taxes you filed in the other country. The tax rate may be somewhat different. You may have to pay a little bit of a difference in one country or another. But in general, it's not double taxation. People think it's dollar for dollar. If I owe $500,000 here, I owe $500,000 there. That's not the case. There is one that says, what are the tax laws that apply to American citizens wanting to move to Canada, but maintain their employment with an American company? That question is actually a question of Canadian law. If this were reversed, for example, and we would have a Canadian citizen wanting to move to the US, but maintain their employment within Canada, that is actually a no-no under the US law, because as long as you are performing labor and employment that could theoretically be performed by a US worker, you are not allowed to engage in any employment, paid or otherwise, for any company anywhere else in the world. On the other hand, the enforcement of that, it's kind of difficult. I don't see how they could say that you work for a Canadian company and you get paid in Canadian dollars in a Canadian bank account. The restriction is actually where you are physically located when you are doing the work. Talk to an immigration attorney on both sides of the border to make sure you're clear and you are respecting both sides, because you might have a problem after a while. Okay. We are Canadians hoping to travel back to Canada for about around a month during the holidays. Should we expect any trouble returning to the US after? I know that's probably frowned upon during this pandemic, but we will not be visiting too many people, just our closest friends. Are other people doing this? Yes and no. We have people who just don't want to travel at all. We do a lot of family immigration, and cross-border travel is significant, specifically for those who are in immediate family relationship, one spouse stuck on one side of the border, one spouse on the other, or when there is a fiancé on either side, and those people actually choose to travel, quarantine for 2 weeks, and prove that they are able to quarantine for 2 weeks, and they just choose to do that. They do travel by plane because they don't want to take the risk of being turned away after traveling to a border crossing. If you do go, for example, to the Toronto airport, US immigration checks you in there. And if there is an issue, at least you're not leaving the airport. You don't have to go a few hours away to a cross border. somebody who's currently who's a permanent resident in the United States, if I temporarily move back to Canada and work for a US company, how would that impact my taxes? Well, there are more than taxes that you would need to be concerned with in this case. First, if you temporarily move back to Canada, but you are a permanent resident, what happens to your permanent residency? When you say moving, how long are we talking about? If you are going to stay outside, you have a permanent resident, you're a green card holder, and then you are moving back to Canada. If you are doing that for less than 6 months and you can travel back here and then stay here a little bit and travel back to Canada again, theoretically, you shouldn't have a problem. It will delay your citizenship. However, if you at any time stay longer than 1 year outside the United States, your residency is considered abandoned, and you would have to get, they might ask you to abandon your residency when you try to enter the country again. To avoid that, if you know you are going to stay outside the United States for longer than 6 months, you should file for a reentry permit with USCIS prior to leaving, and you have to still be here when they send you for your for your fingerprints. And after that, you can leave. They can send your reentry permit to the local US consulate. Okay, so that's the first issue. You need to be worried about maintaining the residency if you have any hope of coming back later on. Let's say you didn't do that and COVID caught you on the other side of the border. You need to make sure you maintain a residence and the domicile in the United States. That means a lease or a home, utilities, car registration, car insurance, and so on, to be able to show that you have not abandoned your US residency. If you can show that, you can go to the US Embassy abroad and apply for a returning resident visa. That's an SB1 visa. Now, to your question, if you are in Canada and work for a US company, before we even get on how that would affect your taxes, see how much we can get out of a simple question? Then you would need to talk to a Canadian immigration lawyer, because if the reverse were true, you would be in violation of US laws. If this is you being on a permanent resident, if Canada is your home country, then you don't have a problem. If you are from a third country and you want to move to Canada, then you would need to talk to a Canadian immigration attorney to advise you if you can work there, even if it's a US company, okay? But while you are physically located there. How does it affect your taxes? As we discussed before, it really depends on the tax treaty, and it's no such thing as dual taxation. Yes, you might be liable for more. US requires payment of taxes on worldwide income. So even though it's a US company and you're in Canada and they're paying you perhaps Canadian dollars or US dollars in a US bank account, you would have to pay taxes on that. And if it's a US employer, you're getting a W-2 anyway. Somebody else who is a permanent resident, has a green card, what's the maximum amount of time we can be out of the US while on green cards? I think you heard my answer before. Hopefully you're attending. Again, it's 6 months maximum. That's on a rolling 12-month period. Okay, so if you left in December and you just came back and then you left again, you cannot do another 6 months because 12 months haven't passed. We are still in September, so it's 3 months plus 6 months is 9 months, is too much. You cannot be outside the United States longer than 6 months without presumptively abandoning your residency. You would have problems coming back in. The biggest risk, and people oversee this, is a permanent resident card is issued by Department of Homeland Security, which is USCIS, and it's a benefit, it's not a right. And they, ICE officials and CBP officials have the discretion to allow you back in the United States or not. All it takes is for one officer not to like your face that day, and I hate to say it, but that's the way it is, and they're very picky, to allow you back in the United States. If they do so, as a permanent resident, as a green card holder, they generally would have to allow you back in the United States, but they are not obligated to allow you back in willy-nilly. They can also put you in removal proceedings and force you to go before an immigration judge and prove you didn't abandon your residency. Another question that I'm skipping the questions that were posted that apply to Canadian law. Like I said, I cannot address those. I'm currently on F1 STEM OPT, and I have an approved H-1B consular processing, and I'd like to use that when re-entering the US in January. What documents do I need to present? Is it usually difficult? Also, if the executive order preventing me from using my H-1B gets extended, do I have any other options? My STEM OPT expires in June. First, many things can happen between now and June. The H-1B executive order has been challenged, and I have seen a change last night that I didn't have a chance to review. You probably at this point, since it affects you, you know more about it than me because I didn't get a chance this morning. But STEM OPT has different rules and regulations than regular OPT, and up to 90 days, you should be okay. Now, when traveling back in the country on, if you have STEM OPT and you want to come back in H-1B, but your H-1B, your STEM OPT doesn't expire until June, I would keep the STEM OPT for another 6 months, because entering on H-1B, you're actually losing from the time that you would otherwise have. So if your STEM expires in June and you're traveling in December, you're changing your visa type, you're not tolling the time that it's available to you from OPT. I would stay on OPT for as long as I can and then travel back and forth and be able to come back in next time on H-1B. Talk to the employer though, because it may make a difference to them. And I think those are all the questions that I have up until now. So I will leave it up to, I will stop sharing.
More Connie for you.
Yes, let me just stop sharing. There you go.
Have popped up while you were talking. I think some of them you've answered, but I'll read a few of them and see if there's nuances.
Great. Let's do that.
Perfect. Well, one of the questions is, it's very common for Canadians to have winter homes in Florida, for example. What does that look like for people that have residences in the US, and what does that look like if they have their family members? Can they come visit as Canadians?
Nothing has changed in terms of how often can you come, how long can you stay for. Nothing has changed on that. The only restriction is really, do you want to quarantine or not? Okay, that is really the major restriction. That's a personal decision. If you are saying that I have property here, but I don't have any family member here, and you're not an essential worker, then no, you cannot travel, because they will likely not allow you to come in. If you especially here in Florida, I don't know in other parts of the country, but especially here in Florida, most of them already have immediate relatives here. Either their children are already here, grandkids are already here, they can show an immediate relative relationship. Those are fine. If they are essential workers, they are not traveling as far as Florida, so their property here will not matter. And I'm assuming it would be the same in California. Now, if you're upstate New York, it is likely that you could be in Syracuse and traveling just to wherever, Albany, Gananoque, whatever, the Thousand Islands area, you can travel there, and there it's an issue at the border. Would they allow you in or not? Now, since border crossings are the issue and not flying as much, that is a restriction. But if you're working there, and there are people who work across the border, they go across the border every single day because that's their job. We have firefighters who work in Watertown who are Canadians. Okay, they travel every single day back and forth to their jobs, and they don't have an issue because they are essential employees. Now, if they just have a property, unlikely.
Okay, thank you. I am a Canadian citizen and on a TN visa. I want to work in Canada for a short period of time, 3 to 6 months. What Canadian tax issues do I and my employer need to consider? If there is an impact, is Canada enforcing these rules, or are they relaxing them because of the pandemic?
I don't know what the Canadian tax rules are. I don't know anything about Canadian rules, but you're probably going to have to pay taxes in both places in one way, shape, or form. Okay, but again, it's not dollar for dollar. That's the biggest misconception out there. That's the one question we get the most, and that's not true.
We have a student one here, which I think is interesting. Can we address American students who are having difficulty traveling to Canada to attend university? I think that's a question for Jade, isn't it?
It's a question for Jade, because the issue is, are the Canadian authorities allowing them to enter Canada?
That's right. To the person that asked that question, please share it after. We'll be happy to share it with Jade, who takes care of the Canadian law.
And we'll share all of the questions that we haven't addressed from the poll that were pertaining to Canadian law. We'll be very happy to share them with Jade, but we do not know, because they were all anonymous, we don't know who asked them. So feel free to email me, and I share everything with Jade. Jade is my Canadian partner, and we help each other all the time with all the cross-border issues. So if you don't have Jade's contact information, you have mine or Melissa, and she'll direct it appropriately.
Great. I have one more here. You tell me if you've already addressed this one. If my US company does not have any presence in Canada, I am on a TN visa, and I'm legally allowed to work in Canada am I legally allowed to work in Canada from a tax perspective? And then she shared that her company has stated that all employees are not to work internationally. And they said that the reason is because there's a percentage of time, 75 US, 25 Canadian dollars.
Yes, but those restrictions have been laxed to a certain extent. If that is an issue of contract, okay? In most cases, they can change the contract and they can change the terms of the employment to reflect the new situation we find ourselves in. But talk to the employer's legal counsel. They might be able to address that with you. Many employers I have seen do that when they really don't want the employee to be elsewhere. They want to exercise control over the employee. Now, that being said, how does the employer know where you're physically located? That's all I'm going to say. How do they know? I'm not saying break the law, but how really does the employer know where you're physically located? Because there are ways, there are VPNs, anyway.
Yeah, no, there's a lot of tech people here.
I figured.
I have a new one here. I am a Canadian citizen, and I have a 2-year home country stay requirement due to a previous J1 visa. I currently work in the US under a TN. How long can I work in the US with a TN, and will I be obligated to eventually go back home for 2 years?
Absolutely. If you have a J1 and your J1 has a Section 213 2-year home residency requirement, you absolutely need to be outside the United States, outside of its border, for you to meet that requirement. That is very typical with doctors, physicians, people on PhDs, and management consultants, okay? That happens quite a bit. If you do have that, there is a way to obtain a J1 waiver, and it all depends on who paid for your exchange program when you had your J1. If it was supported by the foreign government entirely, it's one story. If it was supported by the US government or a US employer, it's a different story. You might actually be able to obtain a J1 waiver. Give us a call, we can look into it, and we can help you with that.
Fantastic. Does being turned away at the border have a permanent effect on your border record? Can this impact future border crossings?
That's a loaded question, and yes, the answer is yes. The reason you need to find out why exactly. Just type in the chat or again and tell Melissa, why did they turn you away? It's confidential. I don't see it. It doesn't. Okay. It's very common. Especially Canadians, they get turned away at the border and they are not necessarily given a reason in some cases. There is a record. Every time you try to cross the border, there is a record. They swipe your passport. Whether they give you the reason or not, there is something that the officer saw. Generally, you overstayed even by 1 day. There is a record of you having worked in the United States without permission. they're in secondary inspection or waiting to cross the border, and they could have asked to look at your phone, and they saw that you were having a job offer someplace, so you're not coming as a tourist, you're coming to work. Or they are perceiving you to be an intending immigrant. Perhaps they saw some texts with lots of emojis and loves and kisses with somebody who's a US citizen, and they are assuming you are coming to the United States to become an immigrant, get your green card here rather than doing it through consular processings. Those are the four most common reasons that you would be denied. And yes, if you are denied, it will affect you later on. The scrutiny will be higher because they are going to question again, why were you denied the first time? And you have to try to overcome that. Can you overcome it? Most cases, yes. Not all the time. Did we get the additional information from this person? No?
No additional information. I wonder if it was specific to COVID though, trying to travel right now so she just responded for trying to cross COVID border restrictions.
Yeah, they will have it. Here is another thing. Many people say, well, I can travel. I have a fiance there, okay, and I need to travel to see my fiance. And that's the most common that we see, because then they think they're fitting under the immediate relative category. And the truth is they're not. If they can show, however, that they're coming here to see their fiance, but the fiance already filed a fiance petition for them, and they intend to go through the legal process to actually do it that way, they are not considered an immigrant relative unless the officer doesn't like their face that day. And then they are going to be allowed in. It really depends on the statements you make to an officer. The shorter they are and the more vague they are, the better it is. Just don't lie.
So to follow up on that, if people are going to the US, to Canada for the holidays, they're visiting their families, it shouldn't be a problem.
Going to Canada, I can't address. Coming from Canada to the, that I can't address. Coming back to the US, that's another story.
Gotcha. There was a follow-up on the 2 year from the J1. Can they do their 2 years outside of Canada in a different country?
It's home residency, home. Okay, but in some cases we can get waivers. If you're here on a T1 and you still have 2 years on your T1, it's worth trying to get the waiver, because maybe when the T1 is over, you don't have to worry about the J1 anymore, because by then you've had the waiver, if it's possible.
I have a good one here. I don't know what your knowledge of the US-Mexico border is.
Those are different kinds of TNs.
I have a TN. This is a Canadian person. I have a TN. Recently, I've seen American friends from the US travel to Mexico. Is there any risk as someone on a TN to cross the border?
Yes, you are traveling on a specific type of TN visa. When you travel on a TN visa, they give it to you for 3 years. Usually for the Canadians, it's usually the first time for 1 year or 3 years, and then the second time for 3 years. I don't know how long you have had it. It depends. Do you want to go to Mexico just for fun? Are you going to use Mexico as a third country to go someplace else? Are you going to go there just so you can circumvent the laws of the United States and go to Mexico and try to come from Mexico to the United States? It really depends. Depending on what your plan is, I can probably advise you better. But unless I know the ultimate reason as to why you're trying to do that, if it's just for fun or for pleasure because you want to go to Cancun, now is not the time. Don't try it, because if you get a denial, like the previous person asked, if you get a denial, it will affect you later. And then you're going to have issues coming back in, even from Canada with the TN, and that's just not worth it. It affects your employment.
Thank you for that. There is a follow-up question for the Florida. So if grandparents, for example, have a residence, they go to Florida for the winter, can their family members go visit and state that they have family members in Florida?
Immediate relatives under US law are considered spouses, children, and parents. So you can't go visit grandma and grandpa, but you can go visit, your mom can go visit grandma and grandpa.
Okay.
And I would not do the cross-border, go by plane.
By plane.
Generally by plane, you will not have issues. Try that. What's the worst thing that can happen? You pay for a plane ticket and buy it with a $75 or whatever it is change fee. Right now with COVID, they're actually, most airlines don't even charge those fees anyway. And if you get denied, you get denied. But what's the worst thing that can happen? You wait 2 hours for immigration in Toronto airport.
Right, because those people aren't on work visas or anything.
Yeah.
All right, do we have time for one more, Connie?
Yes, we do.
Born in Canada, but originally US citizen. In retirement, born in Canada, but naturalized US citizen. In retirement, if I can keep a home in the US, can you clarify that I can spend up to 6 months in Canada and not have to pay Canadian taxes and not affect my US taxes?
I cannot clarify that, first because it's a Canadian law issue, and second because it's a tax issue and I am not a tax professional. You're a US citizen, theoretically you can be anywhere. You're also a Canadian citizen, theoretically you can be anywhere. Since you are retirement, what will be most affected by this, especially if you do live in Canada right now, is the health insurance. Because the type of health insurance Canadians have requires you to be in Canada 6 months plus 1 day at a minimum. And that's a bigger consideration than your taxes. Talk to a tax professional on that. But again, remember, it's no double taxation. Well, hope that was useful.
Very, very, Connie. I know this this impacts people's lives and family relationships, and it's very meaningful that you were able to join us today. It's greatly appreciated.
Oh, it was my pleasure. I hope I addressed at least some of the people's concerns. And if we can help you in any way whatsoever, you find our name on the registration for this. You'll find my name, Google it, it's fine. Nobody expects you to have the contact information. It's Connie Kaplan, lawyer.com, and all the information is on our website, how you can reach us. And if it's a Canadian or tax law issues, if it's anything we can help you with, we know everybody. So we'll be very happy to pass your information along or send you the right person so you can have your issue addressed. It's my pleasure, Melissa. Thank you so much for inviting me.
Thank you. Have a great weekend, and thank you for everyone for joining all over the world.
Oh, thanks. We'll talk soon. Bye-bye, everyone.
Bye.